he's killed porcupines, which is armadillos. They sit there and play with them all. It's fine. But yeah, that's.
We were watching one time and we had to go.
Yeah.
Yeah. Yeah. No, not word for word.
Good for you. I was gonna say,
I got more important things to do.
Yeah,
I read most of it. Or skimmed it.
Yeah.
Who's that lady talking to? She know all she knows.
I don't know who that is. I know.
Mm-hmm.
Harvey, what you know?
They have to
You behaving yourself?
see me.
Very good. Ain't complaining. Don't do any good anyhow.
I have had a couple of moments.
Mm-hmm. Yeah. If you have a good point, if you got a valid point, I mean,
What is the T?
we're good at listening and
Especially if you can show that like you were commercial or changed to residential.
Well, that's me. You know, I've been pricing farms for too long, just walk away from it.
Anyway.
I'm only not read the other one.
Yeah.
You're obviously not impressed with my off-brand.
Dynamic.
Oh, really? Yes, sir.
Transgender deal. About.
What's T-Davies at once?
Let's see.
I call this meeting the City of Kerrville Planning and Zoning Commission order at 4:31. Dorothy, would you call roll, please?
Yes, sir. Bob Waller,
Here.
Garrett Harmon,
here.
Trisha Byram,
Here.
David Jones,
Here.
Rustin Zuber,
Here.
Bill Morgan.
Here.
Thank you.
Okay, we do have a quorum. The consent agenda. The only item is approval of the minutes from the June 2019 meeting. I'd ask you to review those. They start on page 3 and go through page 5. I'll accept any comments or amendments that need to be made. If none, I'll accept a motion.
I'll make a motion to approve the minutes as presented.
I have a motion. Do I have a second?
I'll second.
I have a motion and a second. All in favor, raise your right hand. Passes 5-0. Item number 2 is a public hearing consideration and action. Drew?
Thank you, Chairman. This is public hearing, consideration, and action to approve an ordinance adopting the City of Kerrville, Texas zoning code, a comprehensive rewrite of the city's zoning regulations in accordance with the Kerrville Comprehensive Plan, Kerrville 2050, to be known as City of Kerrville, Texas zoning code, Chapter 60 of the city's Code of Ordinances, adopting the official zoning map of the city, providing maintenance thereof, and providing procedures to amend said map, repealing in their entirety all ordinances or parts of ordinance inconsistent herewith. Kerrville Comprehensive Plan identified several sections of the Code of Ordinances that needed to be reviewed and updated. One of the big pieces was the zoning code and other development-related ordinances. The draft you have today in front of you is a result of significant staff and consultant work, significant public input. It had several stakeholder meetings in October, 6 meetings with the Code Review Committee, a joint City Council and Planning and Zoning Commission meeting, public open house in May, and now 2 public hearings with the Planning Commission. Overall, the proposed code is more representative of the vision from the 2050 plan of the community's future of Kerrville, and the plan should more adequately accommodate the future development and reinvestment of property within Kerrville. Reduction of number of zoning districts up to 65%, from 49 districts down to 17 districts. Reduction in the uses that require a conditional use permit in that process. And a code that's easier to navigate and requires less interpretation. The ordinance also has a provision for city staff to bring back a report to council within 6 months of adoption for review and update and possible recommended changes following that 6-month time frame to use, apply, and work with developers in the code. See if there's any inconsistencies, anything that's been missed or needs to be added, or any amendments to those regulations. Following the recommendation of the Planning and Zoning Commission today, the zoning code will be presented to City Council on August 13th and August 27th. August 13th being a public hearing as well. And with that, I'd like to hand it over to Monica Hyde. She'll go into the details of the updates from the last Planning Commission meeting.
Thank you.
And I appreciate, Monica Hyde, Prologue Planning Services. I'm here with Mark Bowers from Kimley Horn and Associates. Kimley Horn has been the lead or the project manager on this particular project, and I am a sub-consultant and partner with them in it. I appreciate Drew mentioning the fact that I believe we've said this to you, and I certainly know we've said it to the CRC. We know, standing here today, that this code is not perfect in its draft form, and that there are going to be situations that arise in the coming months and in fact in the coming years that would suggest that a need to revisit it on a periodic basis and address any issues that come up. So I'm appreciative of Drew for pointing that out to you at this point in time, so when one does come along, it won't be a shock to you. Today's presentation is going to be focusing on a fairly straightforward outline of items that we want to address with you since the last public hearing. And we'll be talking with you about zoning code edits, zoning map edits, and then have some discussion at the end. So let's move first to the draft zoning code edits. It was pointed out to us that it would make the document a little bit more user-friendly if in the table of contents where we have the appendix listed at the very bottom, and I will say that all of these are fairly minor edits, just so that you know that. It was suggested to us that we list the items that would be included in the appendix, such as the figures that we developed to illustrate certain concepts, the land use table, which is obviously very important, the zoning map itself, and a new downtown core map that I'll talk about in a moment that we think also has a good place in the appendix. Also, there was one particular term that we thought could probably be reworded to be a little bit more broad, a little bit more flexible, rather than designating a specific position within the planning department as responsible for certain elements of enforcement of the zoning ordinance. We're saying chief planning official. That way, as staffing changes in the coming years, months, whatever, it's not limited to the director or the chief planner or whatever. We have a generic term, chief planning official, that we'll use throughout the document. In the district regulations, as a result of some discussions that we had with the CRC, we noted that there was an inconsistency regarding the requirement for alley access for certain housing types. And what the committee had agreed to was that any lot that was less than 45 feet in width would need to have alley access, and this is largely because of problems that are created by very narrow lots with on-street parking and front driveways and that sort of thing. So the proposal was that if you have a lot that is that narrow, that there be an alley required. Doesn't mean you can't do a larger lot to avoid that requirement, but the physical and functional characteristics of those very narrow lots do create problems. And then there were some legislative changes. As you know, the legislative session was just adjourned back in May, and so there are some items to be addressed there. The city attorney has been working on those for the most part with another legal firm. Some of those changes would include limitations on the city's ability to regulate building materials. As a city and in your zoning code, you didn't have a lot of that taking place, but there were a couple of districts where it happened. And so now the way the law is passed, it's minimum standards under the building code that would apply. There may be some potential changes to the review processes that address timing requirements. If you are aware, for a subdivision plat, there has to be a definitive action taken by the city, either approve it or deny it within 30 days or it becomes approved automatically. And there is a need to look at other processes to see if there is a time clock under new legislation that has kicked in for other procedures like platting, like zoning, perhaps ZBA. Other changes to the ZBA with regard to who may file for an appeal. And then, as you know, your life care development or your group home types of uses are very complex. And so the attorney has been working with the outside firm to try to clarify some of those things. that would comply really with court rulings as opposed to necessarily legislative changes. And then there were some formatting, typographical, and wording changes that cropped up in the process as well. I also wanted to bring up to you a potential edit that came to the attention of staff as a result of discussions with the property owner that had to do with the setback in the downtown core area for buildings. Now, you may recall that we had essentially set up what was a build to line, which means that a building on a street in the downtown core, where you have a very different character of development, as you know, would be located nearer the street as opposed to far from the street, like it might be set back in other commercial corridors. So the thought was that perhaps we take another look at that, and because there are some arterial streets within the downtown core, Main Street and Sidney Baker, perhaps on those streets it was more appropriate to give some flexibility with regard to setbacks, particularly because, for example, on the north side of Main Street in certain locations, it's a more standard commercial area, whereas on the south side, it's the downtown core. So there would be sort of an inconsistent sort of a frontage along the street. So the thought was along the local and collector streets within the downtown core, which is a small area, shows up on the next slide, we would go ahead and stick with that build-to line, building the structures closer to the street. But along the arterials, we would allow that zero setback, but not put a maximum. All right, so rather than a 0 to 10, it's a 0 minimum and whatever else might happen, whatever else might be appropriate. That would apply along those arterial streets only within the downtown core. The other thing we did in that particular section in the table that you see behind you or in front of you is that we made it clear that for the front setback outside of the downtown core is also a build-to situation, not a minimum setback. So it's a 0 to 10 as opposed to a 10-foot minimum, for example. All right, so that's just a clarification. The intent there has not changed. And then the last item that had to do with the zoning code itself, outside of the map, had to do with the map that I mentioned to you in the downtown core. Right now we have a definition that defines the boundaries of the core area, but we didn't have a map in there. Your current code does have one, so we thought, well, rather than having to have somebody go in and hunt down the definition, let's just put a map in there and make it easier on people. I suspect that in the ultimate document, we're not gonna have it a colored map, because that way, if somebody goes in and changes the zoning on property that shows in that area, the map has to be changed too, so we'll just do an outline of the boundaries, I feel, in the final document. All right? So now I'll let Mark talk about edits to the map.
Thank you, Monica. So if you recall in the last meeting, the bulk of the conversation took place related to the map and some of the specific details related to specific properties. Some of the issues that came up with, in some cases where we aligned the future zoning on the new map with an existing use rather than with existing zoning. We took that process early on with the residential areas of the community because we really saw that as being the most compatible way to translate the residential to residential and keep from having nonconformities through that process. But there were some areas, for instance, within your old RT district where people had the ability to do commercial buildings on those properties or convert buildings to commercial buildings. And so that started to create a discrepancy. So that was a lot of what we heard about at the last meeting. So we've gone back in and case by case along some of your major arterials. We also started looking at commercial zoning and trying to make sure that the zoning that was in place on that old map was in alignment with what really made sense based on what was on the properties in that area. The third thing was related to public and institutional. We have the P&I public and institutional district now, and we had schools, but we also had nonprofits in there. I think there was some discussion on the part of this commission that we should take a different look at that, and there might be some schools and churches that were included, but perhaps some of the other uses might not be things that we should have in public and institutional. Perhaps they should be in a district in case that use changes in the future. So I'll go through some of the specific changes that were made. We have a map just highlighting the general area. I'm not going to get in point into specific properties, but the first area that we're going to talk about is the Junction Highway near Arcadia Loop. Essentially, we changed the properties previously shown as R1 within that area to C2 due to their frontage on Highway 27. Again, because of that major arterial, we thought commercial uses made more sense all the way along that area. Junction Highway, Thompson Drive, and Goat Creek, we changed the map to provide more consistency between C3 and C2 based upon what was on the ground, and removed R1 and PI zoning in that area. So the next map area is at Holsworth Drive. We updated a parcel at the soccer fields from PI to PD, since that is the existing zoning that's in place in that area. Santra's Barbershop property was changed from R2 to C1, since it's a commercial use there. The water tower and drainage easement changed from PI to R2. Again, we're trying to focus PI on schools, church buildings, and those types of things. So Francisco Lemos created a more consistent commercial zoning from the Guadalupe River to Shriner.
You need to back up one
Oh, I
slide.
went through two?
There you go.
Sorry about that. Francisco Lemos created a more consistent commercial zoning from the Guadalupe River to Shriner, and we changed 3 R1A lots on Jefferson to RT, and closer ER clinic from PI to C3. Oh, and the closed ER clinic from PI to C3. So again, you can see consistently we've tried to make changes based upon whether it had been something in the RT district where it really needed to be more of a commercial use, or just trying to hone in on what some of the commercial activities were, existing activities and properties. Clay Street and Barnett Street created a better transition from the DAC to C2 and R1A and to RT. And then we changed PI on the corner to C1 to match the surrounding zoning in that area. And now on Memorial Boulevard, changed properties along Highway 27 to C2 to provide consistency with current zoning along that corridor. Changed several properties previously shown as R1 to RT to provide consistency with current zoning. And Shriner University property adjacent to the river was changed from Ag to PI. Camp Meeting Road property previously shown as R1 was changed to R2 to provide consistency with the current zoning, and the River Hill Country Club land was changed from PI to R1. So the one thing that we did not do, so if you were to ask me, did we make every change that every property owner asked for in the process? No, we didn't. We tried to go through a process of having strong reason based upon existing zoning, existing use for the decisions that were made going forward based upon the comments that we received from you and the community in the last meeting. There were some things that were discussed that, that property over there, currently it's zoned this, but in the future, we'd like to do this on it, and we think that makes a whole lot of sense, so why don't we just go on and change it now? Again, we want to point out that was not the intent of this process for zoning. It was trying to take what you have today and translate it into the new zoning ordinance. So there were some things that were not changed based on that fact. It may very well make sense in the future for that property and zoning to change, but we would encourage those folks to go through the normal process to change the zoning in front of this body. So at this point, we'd like to open it up for discussion and answer any questions you have.
All right, we call for a public hearing. Before we do that, I want to re-emphasize what Drew said. I want to thank you for your input, your interest. We've had 6 or 7 committee meetings. We've had 2 or 3 P&C meetings. We've offered public opportunity for input, and we got great input. And some of that input went into changes that have been made in this draft. So I want to thank you again for your interest and your input. At this time, I'll open public hearing 449. Anybody wishing to talk to this forum, please go to the podium. State your name and address, please. Before we do that, I have 3 requests for speakers. Let me go through those first. Vincent Focal.
Hello, Vincent Vocal, 2112 Clay Street, Vocal Land Surveying. I just had a few questions, some things that were brought up by our company and then some other things from the public. One of them is the Downtown Arts and Culture District, that's where we're located. Why are we restricting drive-throughs for restaurants in that area? I know a restaurant's allowed, but a restaurant with a drive-through or drive-in service is not allowed. Is there a specific reason for that?
Drew, you want to address that?
Some of that came from the vision of downtown with the Kerrville 2050 plan. The Code Review Committee also talked about that, and they felt that it was for the downtown environment that the drive-through was not appropriate.
Okay, there's a, like I say, our building has an existing ability to have some kind of drive-through service. What would be the process if we were to change our use to that? Is there a variance, or is there something that we could, or any other company can do?
The way it's currently drafted, there is not a variance process. I think the simplest change would be to add it as a conditional use.
Okay.
Then it would be up to the planning commission and city council on case by case to look at those, to see what that would, if it would be appropriate.
And is there any existing restaurants in the area that would be, that have the drive-through, would that make them non-conforming?
Can't think of any off the top of my head, but
Okay.
I'm not positive.
We talked about this some. If you go from downtown west, you have to go like Francisco Lemus to even find a drive-through, and that's like CVS. If you go east on Main Street,
Yeah, there's not any, are
you
there?
have to go pretty good ways. And I think this is probably in keeping with what the comprehensive plan was moving towards as far as the design. This is a pretty small area, and it does allow for a process. If something comes up, a restaurant that has a drive-in that thinks they need to be in.
And I think the way the existing buildings are where what's existing now, they really don't allow for room for a drive-through. I can't think of a building other than yours that would even accommodate that.
Okay, and then that kind of leads into the other one. How many businesses have we created that are non-conforming? Do we have a number on that?
I know when we looked at the first draft of the zoning map, since that was a big emphasis from the Code Review Committee, matching the zoning both to the existing zoning and the existing use. I know we've significantly reduced the number of non-conforming properties from what we have currently. I don't know what that exact number is, and then of course we've done some map changes since then.
So we did go through this with the committee and on the and again, this was before these latest zoning changes, which potentially helped some of the nonconformities, but the proposed future zoning, the way we gauged it was not, yes, it's definitely not permitted because there were some nuances within what was on the ground. But we went through a process and identified not permitted or likely not permitted in the entire city at 40. On the existing zoning that's in place currently, that number was 157. So one of our goals was to significantly reduce that number. And I know we even went through a map property by property to try to find a way to minimize as many of those as we could.
Right. All right, thank you. And on back to the drive-through, is that going to affect HEB if they have curbside service or something?
Not a drive-through.
It's specific to restaurants with drive-through.
Okay. And then fuel cells are not allowed in the downtown arts culture center. Is there another reasoning behind that? Is it because it's close to the river, or is it just aesthetics, or?
I think mostly aesthetics, but coming from the Code Review Committee, they agreed that wasn't appropriate use.
All right, and this is kind of last one, I guess. for properties that are being rezoned right now, what will be the process going forward if they don't agree with the zoning they have, or would the city be willing to consider, waiving the fee or something if someone wants to protest, or is this, once this is passed, you're kinda on your own?
We have talked about a process to waive those fees if it was more of an inconsistency with the existing zoning or existing use and future zoning. It wouldn't be used as a rezoning process, but we're looking at that, trying to find some language to capture
I
that.
know you mentioned 6 months, that might be a good
Mhm.
window to give somebody. And then, Monica spoke about the timing requirements for review process. Is that timing gonna change, or is it when you submit something, or when the city accepts the payment? When does that clock start?
We're still looking into that.
Okay. Cause I think, we had a project where we submitted stuff with the city, didn't pay them, and, everything fell through, so staff time was spent on it, but
Right.
was never paid.
Yeah, and that's specific to plating. I think Mr. Hayes is gonna address some of that.
Okay. And then, last one for the parking in the central business district now, will that also apply to the downtown arts and culture district? I know there's some language in the central business district where you don't have to have on-site parking due to, okay, so that'll just be in the core, it won't be in the actual arts and culture district?
Well,
I
think on-site parking was basically eliminated in the downtown business district, was it not?
I think it was just in the downtown core.
It's in the central business
Well,
district
no,
now.
I don't think it's a downtown core, it was shown on that map.
Okay.
I think, cause our bank is in that, and so is Pine Plow that went through this process. That's what started it.
If it does shrink down to the downtown core, I hope you revisit that, because the central business district bigger than the downtown core, and
It's,
that's where it's
it's
allowed.
much larger, yeah.
So try to make that same area.
I think right now, it's almost the same parking requirement as the core,
Okay,
which is none.
right. I think that's about it. And, again, I just hope the city, would consider working with the public on their zoning if they wanna change or if they don't feel fit, just try to work with the public. Thank you, guys.
Thank you, Vincent. Corey Walters.
Good afternoon. My name is Corey Walters, 3444 Comanche Trace, Kerrville, Texas. I've been in Kerrville a long time, moved here in 1971, attended Tybee High School. My business background, just so I could brief everyone, just because I think it lends to the credibility of the comments that I'd like to make, is I started commercial retail development in 1978. I've got over 40 years of retail development experience, including working with regional and national tenants like Walmart, Lowe's, Kmart, Penny's, Dillard's, Belk, Walgreens, CVS, Darden Restaurants, which includes like Longhorn Steakhouse, Starbucks, Burke's, Bell's, McDonald's, and many others. My developments range from single tenant as small as 2,200 square foot, freestanding Starbucks to I built and developed million square foot 2-level shopping malls with 5 anchors. My development runs mostly in the South, but in different parts of the country: North Carolina, Florida, South Carolina, Colorado, and our great state of Texas. So I got advised of the revised code, and I started looking into it because I do have property that is located at 601 Main Street, which is currently the Bank of America building at the corner of Clay and Main Street. And I started to get some information from the staff and looking at mostly what changes in the building regulations, setback requirements, but also looked at what the changes in the uses to the CBD as well, which includes my property, which is in the downtown core. And my concerns include, of this new code include impact to the future redevelopment of properties in the CBD, including the DC, and also the review of the revised building regulations and proposed uses, which are, some of them are eliminated, as to their practicality, probability, and for redevelopment. You speak about, properties. I mean, I'll go specifically to some things that were pointed out just moments ago about the restaurant and with the drive-through. And yes, there's probably not, you look at in terms of properties that, based on the existing development that may not accommodate that. But I always think that you have to look past that to look at, okay, what are the properties, that could be redeveloped? Let's look at, my property could be redeveloped. Bank of America could leave. I may be forced to eliminate that building and build a new development. The old Hastings property could be redeveloped in its entirety. And I see this and deal with it all the time. Not only, and that's a pretty large piece of property that I think, could certainly accommodate a restaurant with a drive-through. As well as somebody could easily, put together 2 or 3, 4 pieces of property and come up with an acre of ground to build a restaurant. And, the issue today, I think we're certainly, living in a world that's driven by convenience. And while many of the restaurants used to not have drive-throughs, today, since everybody has a smartphone and an app, you can literally make an order on your app and go to a restaurant and pick it up through their drive-through. I'm seeing throughout the country and throughout national tenants and restaurants that more and more drive-throughs are becoming desired and almost a standard for their new facilities. I've dealt with many restaurants, and I've dealt, and most recently I received a figure that was from Starbucks, and because they're trying to get out of inline locations and go to freestanding facilities. Starbucks tells me that when they have a drive-through compared to an inline location, their sales go up 40%. That's a huge number. Other restaurants that are maybe not quite as morning coffee driven, get my coffee on the way to work, but just say like a Jason's Deli, if you're familiar with them, they're adding drive-throughs in their facilities. And I don't think they would be kind of considered the morning coffee driven. And they say that theirs, when they have a drive-through, their sales go up 25%. So that's a significant figure. And I think when you eliminate that possibility from our CBD district, which is pretty large, and there are many properties that could accommodate this type of use, I think you could potentially eliminate a very fine restaurant from coming into our community. Jason's Deli, Outback Steakhouse is doing the same now, adding drive-throughs. So I just ask that the staff, or not the staff, but the staff and the commission both consider, what the trend that's occurring in our lives nationwide. There are some things that I found interesting as I was going through some of the uses which are now not allowed in the CBD, and I thought, in addition to the restaurants, I thought, it's interesting looking at things that are allowed. If I was living within the CBD or even in close proximity, or anyway, I guess anywhere in the community, I can come to the CBD district and I can get my ear pierced or I can get my nose pierced if I wanted, but yet I can't go and find a hardware store in the CBD because that use has been eliminated. I can, like I said, I can get my ears pierced, but I can't go to a hardware store and buy a wrench, or some light bulbs or extension cord or something like that. And I found that interesting when you have some large pieces of property, and I'm not talking that we're talking about Home Depot or Lowe's, but there are other hardware stores that I've seen locate in close to downtown areas where you have, or you're either maybe denser population or you're trying to promote downtown residential. So this is one that I just kind of picked out. There are others as well that I find that, that are not included. I sat with staff a couple of days ago, and we actually took the old code and the new code, and we were looking at the uses, and I had marked the uses that I thought were possibly eliminated, and we found that it was I found that it was difficult because many of the uses in the new code are specific line items, whereas the old code had some broader language that somebody could say, yes, I fall into that category. But when you get to specific line items, then it's almost up to interpretation or somebody's opinion. And somebody, as I was going with staff and we were going through and going, okay, well, this isn't specifically addressed in the new code, but, it probably would be considered up in this category, or it may be considered up in this category. And I thought, well, this is just, me and this person talking in our opinion, but if it's may or may not, then it more or less could be thrown into a variance situation where somebody's like going, well, it's not really listed here. I don't know if it's really considered to be in this, line item. Therefore, we got to go through planning commission and council to see, get their opinion and get an approval. So I don't know that, and I understand that the previous code needed changes, and I agree with that. But I don't know that with the current line item uses that we're achieving all that we hope to, that we may be also incurring some additional work and review for, because these items are no longer included or can be included in the broader terms that were in the previous code. It's just not possible to include all the uses of all the zoning classifications in 7 pages, and that's what we have under the new code. I mean, it's just, so I do think that, maybe some of this broader language that was in the old code was useful. And I've got a couple of things that, that I could kind of point to that categories that were eliminated. And let's see if I can get to that here. We've got, these are some general categories that were in the old code that are now eliminated in the new code. 1, hardware stores. 2, miscellaneous store retailers. Professional, scientific, and technical services. Administrative and support services. Home healthcare services. And personal care services. That could accommodate for many different types of uses that are no longer, those categories are in the new code. Anyway, if I have anything else, I've got, there's, I kind of go back to my tattoo and body piercing. I find it interesting, as I mentioned before, that can be allowed, but nowhere in the CBD are there veterinary services. Like I said, I can get a tattoo, but I can't take my dog to get, some medical care at a veterinary clinic in the CBD. And I'm not talking about because this is just without a kennel. So just a clinic, just an office. And, there's other things that I find that are not included that I feel like should be. And, outpatient care centers, those are excluded or not, or excuse me, maybe they're not addressed in the new code. Some rental places, the new code doesn't have a line item for videotape and disc rental. Even something as simple as a GameStop doesn't exist. It's like, staff and I went through all the line items. We were like, well, yeah, maybe you could put that in the department store. Well, department stores really don't have, rental of DVDs and discs, but at the same time, the point is we couldn't find a category in which to put it into or to say it's allowable under this use. So I do think that there's some areas that are being missed, and I wish that staff and the commission would back up a little bit and address some of these issues before they look to vote.
Thank you, Court.
Thank you very much. Appreciate your time.
Kathleen Printman.
My name is Kathleen Brinkman, address 444 Sidney Baker Street South. I represent LDB Corporation and its subsidiaries. I'm president of LDB Corporation. I've got 2 parcels, well, 3 really, but I think one's not a problem. I'd like to start with a question though, just so I don't address something that might not need to be addressed. Our property on Sidney Baker Street was originally designated as an S33. I had on June 25th, I met with the staff and with the city manager, very generously met with me to go over these issues. And I came to this meeting today thinking this was all resolved, but unfortunately it doesn't appear to be. If I can ask, you didn't note any changes to the Sidney Baker original designation?
Well, they might have been made before this last round of changes.
Well, it would have been made recently because it was June 25th.
Just 1 second. You talking about the office building?
Yes. Did we get, that's not.
Yeah, it's changed.
It is changed to multi-use.
There we go.
So
Yeah.
that's it, multi-use. Okay, good. Then that one I don't have to address.
Yeah.
And then R3 on the other one.
Yeah.
No, on the small one, but
Oh,
we all
right,
agreed on
right,
that.
right.
That was before. Okay. So the only one I need to address is the Camp Meeting Road, Camp Meeting Creek as we call it. The theme I've been hearing consistently throughout your meetings and from the staff and city manager is that the intent is not to change anyone's zoning, but that is what in fact you are doing on the Camp Meeting Creek property significantly. I have my own piece, but I don't have any way to show you what was there previously, except I've got a copy of the previous map designation. And I don't know if you can see this purple section. I can hand this up if that's allowed. But that was a commercial designation. It was S37, light commercial, professional office, and multifamily housing on that front section that abuts Highway 16. That's a really important piece on this property, which I might add is currently for sale and has been listed for sale for some time. It's also been getting a lot of interest because of that commercial designation, because that has lots of value associated with it. The back parcel was designated residential cluster, and at the meeting on the 25th, I agreed with staff that that back section would be designated R2, which would be a consistent alignment in the new code versus the old. But the S37 is not, and yet I come to this meeting tonight to find out for the first time, and it's been almost a month that the agreement that we had on the commercial section to designate that as a multi-use portion was not put into the new plan which you're being asked to adopt here tonight.
True. Is that something y'all addressed?
As we looked at it, with the existing boundary actually cuts through, or leaves a small sliver beyond the church property, overlaps the creek property. We weren't comfortable drawing another arbitrary boundary without any specific platted lot or separate property lines for that. So looked at R2 for the entire property until that site is established, and then we would look at a change to come closer to that S37, which is the mixed use that we talked about.
But no request was made to me to provide that information, which I could have done so that we could have gotten this resolved now. Now I'm in a situation, I don't know what situation I'm in, because I'm trying to sell this property. I have people interested in the property. I'm losing my commercial designation for that section. And what's the process? Do I have to go in now and do a zoning change? Is my purchaser looking at having to go in to do a zoning change? Losing that commercial significantly impacts the value of the property of the company.
So that commercial area currently isn't platted as a separate lot, or is it?
That's what they're telling me. I don't know. I wasn't asked to ascertain that either way. It may be. I don't know why it was set up this way in the first place. It's been this way for decades, as I understand it. But I'd have to check my records, which I didn't have the opportunity to do. I possibly, too, could have gotten someone out there, gotten the lines drawn, figured it out, and come back and presented it in the 4 weeks that have gone on since we last met, but I was given no opportunity to do that. I'd like something.
Well, what I would recommend is you get with our planning group and visit with them if you have those papers, or you can, they'll let you know what needs maybe to be drawn up to make that modification.
Well, that's fine, and I'll work with them to do that, but what's the timing here? I understand I have till later in August to get this accomplished, because I've got other things on my plate, and my time's not all myself. And it just seems surprising to me that I'm losing my zoning without any notice, basically, here, and with additional requirements being imposed on me as the property owner. Not that I'm not willing to work with them, I am. And if that sliver is the only issue, I can probably give up on that, because who wants to put something right behind the church anyway? It's that frontage section that is really critical to this piece.
True.
So with the commission's direction and as part of your recommendation, we can try to address that between now and the council reading. If not, we can work with Ms. Brinkman following the adoption. And like we said, if we've got some inconsistencies, we can put together those cases and bring them forward.
Well, what's your plan on the inconsistencies? Because I'd like to know if I'm going to be facing a rezoning hearing, or is this going to be by, I don't know, by fiat or?
I can say this, we know there are going to be some inconsistencies. We couldn't cover 100% of them up front. We just, the time, the last time we looked at redoing this zoning was a 5-year process. And, but I think things like this is why we're going to wait and give 6 months. I would imagine the list will grow of those things.
I imagine it will, because I didn't know anything about this
But you will have that opportunity to have that addressed during that time, as soon as you can.
But this property is for sale right now.
Chairman, specific to this property, with commission's direction, we can address that between now and council and get the documents from Ms. Brinkman.
Okay. So in the next 2 weeks.
Okay. Well, I don't know if it'll be the next 2 weeks or not. I have other commitments over the next 2 weeks. So that's one of my problems. Had I known over the last 4 weeks, I could have made it happen. But I wasn't informed. But I'd like so you are going to continue with we're going to keep this consistent. Because I'm just being told tonight that they don't want to give me separate zoning on this piece because it's one parcel, and that they don't want to split the zoning. But that's not the case. Is that correct?
We can get with you between now and council and address it, yes.
But you're agreeing that it's not an ipso facto, that if it's one parcel, there can only be one zoning on that parcel. Because that's apparently what happened to me after our meeting on the 25th.
Yeah, we can look at it. I don't have the information in front of me to discuss it any further. We can address it between now and council.
But the commission is also saying as well that they want to keep the previous zoning consistent, correct?
That was the intent.
Yes, well, okay, good.
Okay. These are things we need to know
Well,
Thank you for
yes.
bringing it to our attention.
Well, thank you. I mean, I was grateful that someone else happened to bring it to my attention because I, like a lot of property owners, had no idea of the significant impacts that this process was gonna have on our property, including significant drops in value. Thank you.
Thank you.
Oh, sure. He knows a lot about this property.
Yes, ma'am. My name's Harvey Brinkman, 306 River Hill, and when this property was put into that, I believe, S-37, it was during a zoning situation. I'm not sure of the year, but I mean, it's got 600 foot, 700 foot of frontage on the highway on 16. It may be more than that, I can't remember, but it's about 35 acres to the north of Camp Meeting Creek. That is the question. And when I got in the real estate business way back, I had an office out front of the church, portable building basically. And when the highway was redone, we took sewer lines underneath the highway from River Hill, or casings, I guess is really what it was, and so that eventually they'd have sewer on that side and on the other side of the creek, the north and the south side of the creeks. And the zoning came about from questions I got from the council at that time, and they agreed that yes, multi-use was a good purpose for that property. Well, I'm reading through the MU, I think that would apply to that property today, still. I mean, apartments could be a very likely scenario. It's not on the major highway, but it is on a good used highway. And I just think that, yes, I don't mind helping Kathleen if she would like in reference to this, if y'all want me to help her get through this next couple of weeks.
Okay, thanks, Harvey.
Sure.
And thank you.
Thank
And
y'all.
Drew, I guess based on that, if you would get with Ms. Brinkman and see how we can move forward.
Yes, sir.
Any other comments for the public hearing? Harvey?
Oh, see, no, ladies first.
Hello, I'm Sherry Snyder. We represent Hill Country Tiny Houses. My husband and I have been building tiny houses for a couple of years. Our address is 102 Old San Antonio Road in Bernie. We have a P.O. box in Kerrville, and we're trying to build a whole tiny house community here in Kerrville. And we love Kerrville. We've been here 7 years, and we want to get back. So the housing trends, we were really excited that Kerrville as a city is speaking out, saying we desperately need affordable housing, and what can we do to solve this problem? So in the past, Kerrville hasn't really been known as a progressive thinking city. Austin has. One of the things that Austin adopted about a year ago was the legalization of ADUs, which is accessory dwelling units. So there's this affordable housing crisis nationwide, and I think Kerrville has an opportunity right now to lead in that and to take this progressive stance. And one of the fastest solutions to the problem, which they're brilliant minds, far more than me, and they haven't quite concluded this yet, but accessory dwelling units. So that means a whole bunch of properties could open up for people to say, hey, I'm having struggle paying my mortgage or my property taxes going up, but I don't want to lose my home or leave. If I could add a tiny home in my backyard, my side yard, and it could be legal to bring a worker be someone who's saying, I'm driving from San Antonio to Kerrville to work at the state hospital, at the Peterson Hospital. I would love to get into affordable home living. I think we could solve a lot of problems for a lot of people just legalizing ADUs. And then secondly, just this concept of, as my husband and I chose to dive in and sell our 2,200 square foot house on Mockingbird in town and live the tiny lifestyle so that we could become a product of our products, understand what our clients face. It's been very, very challenging. Where can we legally live tiny? And then helping our clients all over, not just this area, but outside it's the number one concern. They're like, I love this concept. It is affordable. It helps me win as a system, but where? Where is it legal? So most of them are living illegally, and we want to find a way to embrace that in this whole area and let Kerrville lead the nation. So in that, we would request the density number go from 7.5 per acre to 10. And we would request some grace on the zoning and planning of where can we put a tiny home community in this, preferably in the city limits. And so when we look at specific land choices, we're just having challenge. We're finding it very challenging. So the zoning, the planning, if there's a way that they could just become tiny home friendly. We build beautiful, stunning tiny homes. They've been on HGTV and in magazines. We're talking about beautifying the city and bringing so much value to the community, because this is a community we want to live in, we want to invest in, and it's about the people. If you help the people become even better, they serve the whole community, and that brings value to everyone. So thank you. Is there anything I need to, that you can say, Sherry, go this route? I mean, I'm just.
Well, what I would say, Ms. Snyder, is you've simplified a very complex question, and it's something that we've seen tiny houses grow in popularity. How they can be used here for affordable housing is certainly something we're open to addressing.
I love that. Thank you. You just have no idea. After being rejected over and over, and to have you guys say, we're going to think progressively and differently, is such a blessing. So,
no, it's a good concept.
Thank you.
Mr. Chairman, I was on the code review committee, and that's one of the issues that I kept bringing up. Remember, Mark? Tiny homes. We needed that in. We still haven't addressed that, have we?
We certainly have areas with accessory dwelling units that are allowed.
Does it have to be a PDD, or what is it?
Within the R.
Well, okay, thank you for letting me address the tiny home question. There's one other issue that came up earlier that maybe we can come back to. But as you know, there is a district that we have, R1A, where the A stands for accessory dwelling unit. So anywhere that's on the ground, that would be a good place to start looking for potential tiny home development. And the issue on the broader question of tiny homes was, at this point in time, that type of development concept is fairly new, at least in this area. And I don't even know that there is a whole lot of agreement on what constitutes a tiny home, what sort of minimums should be utilized, should they be available for sale on individual lots, or as a larger community, or exactly what. So I think the way the CRC came down, the Code Review Committee came down, was that R1A is an option potentially, and otherwise probably PD or planned development zoning is the best way to go, where you go in and the applicant comes and writes the standards for you to consider. And that gives them some flexibility in terms of determining all those minimums and maximums, and also gives you some flexibility because they need to present to you additional information as part of a PD application, so you can really weigh all the positives and potential negatives of a situation like that. So there's really kind of two options for someone who wants to begin looking into that possibility. And the issue of the uses and how to approach a table or broad categories, I find that that's just something that the city's preference will vary. Some cities like a broad category, so there's plenty of room for interpretation. Some cities like a more itemized list, so they don't have to make as much interpretation. When we first met with the group of stakeholders that we interviewed early in this process, they complained because there was too much interpretation. And you get somebody that had something for breakfast one day that didn't agree with them, and they might interpret one way, and they might interpret it differently another day. So we actually went in with the idea of trying to make things clearer and less, subject to whim if you want, or interpretation if you prefer. And one of the uses that came up in the speaker's comments was miscellaneous store retailer. I mean, that could be anything. And I know the Kerrville Code had some, they do have some definitions, or a definition with some itemized uses within a category. They also had limitations on the amount of building area that could be constructed under their various retail categories. So we were just actually trying to simplify and clarify, not make things harder and more subject to interpretation. So, you know, it can be a preference. I know planners who like it one way versus another, and we were trying to come up with a system that was Kerrville specific.
Oh, thank you.
Monica, would you mention R2 and the smaller lots?
Yeah, R2 is a district, and I don't have all the minimums committed to memory, but R2 is another district that allows a whole variety of lot sizes, and so that might be another option to pursue. And you may actually find it in a more broad cross-section of locations in the community than you might find R1A, which is kind of focused on the area near downtown. So that's another option.
Yes, sir, Corey. Well, Harvey.
Oh, I was just gonna make a comment. Corey, sorry, can you go to the second? Yeah, I'm sorry.
I'll be quick. Excuse me. I'm sorry, I just wanted to address one of the items that she said, because I was the one who brought up as far as the specific line item uses. I certainly don't have a problem with the specific line item uses. All I was suggesting is that I don't think that the 7 pages that are there cover all the things that exist, and that you may end up, if you stick with just those 7 pages, with many uses that people come forth saying, well, I've got this, and you go to the pages that are to be passed or proposed to be passed, and they're just not there. I mean, what do you do? I mean, it's like, well, it should be here, or we could put it in here, but it's not in there. So then you're left with coming before the commission or council to see something to either be added or allowed. That's all I was suggesting. Is I don't think that you can list all the uses that exist in 7 pages, and where the previous broader terms maybe would accommodate for some of the uses that aren't listed. And I agree with her that miscellaneous store retailers could be anything. I just made a comment that that's what was in there previously. Yeah. I wasn't suggesting that you keep that. So.
Monica, you had comments.
The thing that I would say is, we know those things happen, and the way the ordinance is structured, unlisted uses are considered CUP uses. So you come in and you make a case for the use. If staff cannot work its way around to whatever you want to do without going through a process, that's the process.
CUP.
CUP. And I guess I would say that the other option would be to come in and ask for an amendment. Once the code's adopted, you can always request an amendment to the text of the ordinance to add that particular use, or to revise a definition so that it's included under another term or something like that. So it's really not the end of the road. There are ways to get where someone wants to be if there's a use that we didn't anticipate.
What's the process for the amendment, Drew?
Same as for a zoning change. Same process. Public hearings at Plan Commission and City Council.
Harvey, quick, jump up there while you got you.
I'm offended. I want to thank you for cat herding, because I've been to a lot of these draft meetings, whatever you want. Spent the night at one at UGRA one time. I mean, that thing went till 7 in the morning. And y'all want to try that one? I don't think you do. I think I've got my questions answered, but on an R1A, does that mean a duplex too?
No, it's a single family, and you have the ability to do an accessory dwelling unit either in the main structure or as a freestanding building. Duplexes are now permitted in the R2 district.
in the RM district.
But if you have a duplex in an R1A district already,
It's legally non-conforming.
okay, just want to be sure. Thank y'all. And then the last thing was the timing thing. I think y'all are answering that with the amendment and, but after, if this goes to, when you take this to council next, is there a time frame in that at all? It isn't. I mean, once the draft is signed and delivered, that won't get changes, correct, unless council changes something on the draft?
Well, I think anything that's passed by us or council is subject to change by an amendment or a request.
But I'm talking about, you know, especially something like what Kathleen Brinkman's bringing up for that piece. That's, you know, significant for.
Well,
to
that's
have
why
to-
we'd ask staff to look at that,
Okay.
those tastes.
I think to answer your question, Ms. Brinkman's example, we'll present that to council as a recommendation from P and Z, different from what was drafted, and we'll go through that process. Anything else would at least be highlighted at the planning commit, or the city council meeting, that it was amendment based on the planning commission's direction.
Well, congratulations again on your cat hurt.
Thank you. Any other comments from the public hearing? Corey?
Sorry, one other item out. I just wanted to say, with regards to the restaurants and the drive-through, is I thought that Drew made an excellent suggestion to allow that with the conditional use permit. Then it can be reviewed on a case-by-case basis. If you don't allow it with a conditional use permit, then it's just excluded altogether. And I do think that's a retail arterial street and on Main Street, and I do think it's something that should be allowed and can be reviewed by planning department with a conditional use permit.
Drew, is that available now?
No,
The CUP?
It is not. So we'd have to change the land use table to include restaurant with the drive-through as a conditional
As a
use
C.
in the downtown arts and culture district, right, as a C.
Okay, good point, Corey, thank you. Yes, sir, Vincent.
I just have one more question. If someone's in the process right now of doing a development site plan or some kind of development on their property, but the zoning's gonna change, I believe the end of August, beginning of October, and they're still in the process of doing that, will they be allowed? Is that kind of, did they meet the window, or what allows them to do what they're doing now that?
Yeah, if you've got an approved development site plan or an approved building permit, that would lock it into the current zoning code.
Okay, and it has to be approved before that date?
Yeah, the effective date in this ordinance is October 1st.
Okay, so if they're in the process of doing it and it hadn't been approved and they've already paid fees and stuff, that's.
Yeah,
it needs to
we'll
be-
still review those
Okay,
up to October 1st.
all right, thank you.
Hearing none and seeing none. Mike, anything before we close the public hearing?
Yeah, I just wanted, let me just remind y'all of something. And I don't want to keep you all any longer than you want to be here. Ms. Hyde did a good job pointing out some of the changes that are going to be made, and I just want to re-emphasize. I sent y'all some information about, and this is still a draft document, stamped draft atop the, across the front of it. We are going to address the group home issue, try to basically condense that, make it very clear. We have the ongoing litigation, and so we've been trying to manage that a bit and juggle that, and so we think we're on a path to some rewording there. I'd characterize that as non-substantive. We'll address the legislative changes. Two of those are the building materials that have been mentioned and Board of Adjustment. Again, I don't think those are really going to be substantive. I think it's going to help really in some ways, particularly the ZBA, because basically there's going to be a shot clock. I think we talked about that. And it really kind of moves the process along. I don't think we've ever had an issue with that, but I guess other cities have. And so we're going to, it'll look a little, I mean, we'll track those changes and make sure you all understand what those look like. And, but I just want to make sure that you're really clear. So my advice to y'all, my recommendation to you is that you all are a recommendation body. And so if you're comfortable with this draft, I think the motion ought to be something along the lines of, I make a motion to recommend this draft with the changes that have been outlined by staff at this meeting, and with the direction to staff that they work with the property owner along 16, something along those lines. And I think that'll get us moving forward to council, and then, you know, they'll get to chew on almost a 200-page document. So that's my recommendation.
Okay, thank you. Anybody else want to speak? Seeing none, hearing none, I close the public hearing at 5:40. Commissioners, questions, comments?
I think my one comment would be that obviously we can't satisfy every single property owner with these changes. So we're going to have a process of where we're going to have some appeals and we're going to have to review those. And I think it's important to keep that in mind, that this is not a perfect process.
I agree. David?
I spoke to that last meeting, and I've said also that I totally agree with Kerrville finally coming along and having a real grown-up zoning process. And 7 pages, I don't know, 10 commandments, you get it on a card, you know, whatever it is. But I think in 7 pages, you're going to find almost everything you need. But you're dead right. Something will come along, or the marketing approach on things will change. And so I keep hearing this 6 months that we're going to have. And again, we're assigned to make these recommendations, whatever else. We're also support staff and not make work for them, but to streamline the process. But again, we need to be totally aware, and I think everyone is speaking to it, that there are going to be variations and changes and oh my gods and whatever else that are going to come up when this process proceeds over the next 6 months. And I don't know how formally you have to make it, or if we make a recommendation to the council that there is some flexibility and their recognition and acknowledgement that this is a total pick it up, move it over, and move in a whole new, and just as long as we can speak to it and not have everyone coming in and a process be outlined, or just make sure that everybody has a due process hearing. And you spoke about, Bruce talked at the last meeting about memorial, and that you go along and you can't chop it up so much, and you've done it. Sounds like the variations and the changes that you've made, going from 170 down to 40 and whatever else. I think that can be spoken to, but there are some areas that are just going to be, this is the pockmarked area. We've got pockets of this and the other that we've got to deal with, and I just think it'd be acknowledge it, put it in, and again give staff support and direction in being able to deal with it. And on specific things like that, that's perfect. It's just that you got to get it done. Oh my gosh, you got 2 weeks to do it. Well, do the best you can, but you got everyone's full attention now. So,
I mean, I agree with everything that's been said. It's not perfect. We're trying to be. I think one of our directives have always been, even starting with the Kerrville 2050 plan, is looking forward. Looking to the future, not how things are being used today, but how things could be used and be used for the better in the future. And so that's what our goals are in looking at zoning. And at the same time, I'm just as proud of Texas's property rights as anybody else is. And so I think that's important too, but I also think that there's a balance that can be achieved with it. Lifestyles change, culture changes, and so we need to be thinking forward and moving forward, not at breakneck speed, but at a proper speed in order to meet those changes. And I think that's what part of this process has been about.
Rustin?
Yeah, this has been a good process, I think 8 months, something like that. Lots of input, not a perfect document, as we all said. I do like the edits that were made since the last meeting. Appreciate everybody who was involved in that. Feels like it's really, really close, but gonna need some adjustment as we move forward.
Well, I want to thank everybody for the input. A lot of that input, we've made amendments to the draft from. Corey, all your points are well taken. And Bruce's were at the prior meeting. Any questions y'all have? This is who we need to hear from. People that are in this business. Developing properties, selling properties, leasing properties, those kind of things. I just can't thank y'all enough. It has been an arduous process, but you know, I've been at Kerrville 18 years, and we've been talking about zoning change ever since I got here. And I'm really glad. I think this is, it's a lot more than a Reader's Digest version. It's really well thought out, or the kind of things that come up we didn't think about, no questions. Will we be open to those? You bet. And so, you know, we'll give, I'd like to, I guess, ask for a motion in the form of a recommendation to City Council.
I'll take a stab at it. I move that we approve this draft version of this zoning ordinance, which would include the amendments that we have talked about this evening, as well as directing staff to address Ms. Brinkman's concerns on highway frontage on 16 South. Did I cover everything, Mike?
The only thing I'd like to add to that is I'd like staff to really take a look again, maybe spend a little bit of time with Mark and Monica to see if there's anything we can do to maybe help somebody that comes in with a request of use that's not a line item use now. Just look at that.
And be defined in plain language, understandable language.
No attorneys, that's right. Okay.
A second.
Have a motion, and we have a second. All in favor, raise your right hand. Passes 5-0. Thank you. And thank y'all for your time. Staff report. Drew.
We've got a recommendation to go to the city council with the new zoning code. So the code review committee is meeting July 30th. They're gonna start their introduction to the subdivision ordinance, finish reviewing the sign code, look at the zoning overlays that are mentioned in this document for the airport overlay, downtown overlay, and river corridor overlay. I think that's it. And then schedule those throughout the rest of this calendar year for review for the planning commission and city council. So we're working on trying to get that scheduled and queued up to the code review committee.
Okay, so when is our next P&Z?
We have at least one case for August 1st, and depending upon the action on the code review committee, we may be reviewing the sign code on August 15th.
Okay, any other business we need to deal with? If not, we're adjourned.